Why don't we go ahead and start with Tim Eyman versus Dwayne Davidson, the state of Washington, Washington State Legislature, 18-2-167-234. Good morning to everyone. Once you all get settled, if you go ahead and put your appearances on the record.
Your Honor, I'm Jeffrey P. Eyman, Deputy Solicitor General. I'm here on behalf of the state, Treasurer Davidson, and the legislature.
Thank you, Mr. Eyman. Good morning.
Thank you, Your Honor. Joel Ard on behalf of Tim Eyman.
Thank you, Mr. Ard. And I saw you had put your notice of appearance in on July 25th.
That's correct.
Because Mr. Eyman had made this motion representing himself, and then you were going to come in and do the oral argument.
That's correct, Your Honor.
And you stand by everything that was filed by
Absolutely,
Mr. Eyman. Very good. And good morning, Mr. Eyman.
Good morning.
So, this particular motion for summary judgment by the defendant, I just wanted to let the parties be aware that the court had reviewed the initial motion for summary judgment, the response that was filed by Mr. Eyman, the reply that was filed by Mr. Eyman, as well as the declarations supporting. So the declarations of Mr. Eyman, the declaration of retired Senator Joe Zarelli, and the declaration of Representative David Taylor. The court had also reviewed the declarations in support of the state's motion for summary judgment from Mr. Eyman and the declaration from Ms. Mealy, who is the Director of Policy and Legal Counsel for the Office of the State Treasurer. And the court had obviously reviewed the original complaint and answer as well. So with that, Mr. Eyman, how long do you think you'll need to make your arguments?
Your Honor, I don't think my argument needs to be lengthy. I think I can do it in 10 minutes.
Very well, thank you, Mr. Eyman. And Mr. Ard, how long do you think you'll need?
Take the same 10 minutes that Mr. Richards stated. Thank you.
You're very welcome. Well, Mr. Eyman, go ahead.
Thank you, Your Honor. This case begins, I guess, with a point of good news and a point of bad news. The good news is that ultimately I think the resolution of this case is clear. The bad news is we have to go through a few arcane state budgeting concepts in order to get to clarity. So with that, I will jump straight into the arcania of the state budget. The ultimate question we're dealing with here is whether a particular stream of revenue to be collected from the state sales tax in fiscal year 2019 is or is not part of the calculation that the state uses. Does it factor into the calculation the state uses to make transfers into the budget stabilization account? The key legal concept there is Article 7, Section 12 of the state constitution on the budget stabilization account, and the definition of general state revenue in Article 8, Section 1C. So now the budget stabilization account is designed to deal with swings in state revenue, so that as more revenue comes in good times, some of it is captured into the budget stabilization account, can be used in tougher economic times, and it also allows for the legislature to make appropriations out of the budget stabilization account on a 60% vote. There are two types of transfers into the budget stabilization account. The first and the most common is an annual transfer in which 1% of general state revenues are transferred into the budget stabilization account by June 30th of every year. So it's at the close of the fiscal year. That transfer for the past fiscal year was just recently made. It was a little over $200 million, I think, to give an idea of the scale on that transfer. The second kind of transfer occurs when there is extraordinary state revenue growth, also a defined constitutional term. But what that deals with is sudden upward jumps in state revenues by comparison with the prior decade, basically, there's a 5 biennium look back on this. When the state budget increases suddenly very quickly, there's a second transfer made by June 30th of the second year of a biennium. So that one comes up every 2 years, if it's triggered at all. There has to be enough of a jump in state revenue to trigger that one. It's sort of, you hit a tipping point and then that transfer occurs, otherwise it does not occur. Now, both of those are calculated on the basis of general state revenue, which has a constitutional definition, originally adopted for use in calculating the state debt limit. So this same calculation is actually used for 2 different purposes. But there are 2 passages in that definition that each could be independently dispositive of this case. The first is the beginning definition, and I'm looking here at Article 8, Section 1C, defines general state revenue to mean all state money received in the Treasury from each and every source, including money received from ad valorem taxes levied by the state and deposited in the general fund in each fiscal year. So with that ad valorem property tax portion of the definition, we're only talking about including in general state revenues taxes levied and deposited into the general fund. And we hold that thought for a minute. That's then followed by several express exclusions from general state revenue, one of which is monies received from taxes levied for specific purposes and required to be deposited for those purposes into specified funds or accounts other than the general fund. Now, when we look at the revenue stream that is at issue in this case, basically reciting the statutory language about this revenue stream shows that it's excluded from state revenue under both of those constitutional passages. What we're talking about is a portion of state revenue from a state sales tax that was first authorized in 2017 as part of the McCleary legislation and was amended in 2018 to treat a little bit differently a certain portion of the revenue stream. Now, I should pause for just a moment and say that 2018 legislation did 2 things. One was it put in a temporary property tax cut for calendar year 2018 in that statewide property tax. But then, as a second function, it provided that, and now I'm reading from the legislation, this is RCW 8452-065 2B2. For fiscal year 2019, $935 million in taxes collected under this subsection 2, that's the state property tax, must be deposited into the Education Legacy Trust account for the support of common schools. So we see 2 features of that $935 million to be collected in fiscal year 2019. First is, it is raised for the specific purpose of support of common schools, and it is deposited not into the general fund, but into the Education Legacy Trust account. So it clearly is money received from taxes levied for a specific purpose, support of the common schools, and required to be deposited for those purposes into specified funds or accounts other than the general fund, the Education Legacy Trust account. So that's a very straightforward application of the constitutional definition. Now, Mr. Eyman's claim in this case depends upon concluding as a matter of law that that $935 million is included in general state revenue, but when we look at the constitutional definition, it clearly is not. That is the clear answer to this case. Mr. Eyman's complaint should be dismissed because simply as a matter of applying the constitutional definition, this revenue stream is not part of general state revenues. If the court has any questions, I'd be happy to take them. Otherwise, I will let Mr. Ard have his turn.
Thank you, Mr. Eyman. I don't have any questions for you at this time. Mr. Ard.
Thank you, Your Honor. I'm sure you've heard the parable of the blind man and the elephant. And one of them comes up and grabs the elephant's tail and says, "This thing's a rope." And one of them finds the elephant's trunk and he says, "This is a snake." And one of them grabs the elephant's leg and says, "This is a pillar, this is a tree." We need to step back because there's an elephant in the room. And the state has done a fabulous job of identifying how it can dodge the snake and cut the rope and push over the tree. But what they're missing is the elephant of a constraint on the legislative authority that's found in the Constitution. So it's not enough for the state to be able to come in and argue, how do we get our way around each individual constitutional constraint on legislative action? These are a web of constraints on the state legislature that limit their ability to do this very unusual, in fact unique in the history of Washington, act that they took in the last legislative session. It is normal and natural for the legislature to push against the constitutional constraints that are on it. They are always going to want to expand the boundaries of their power and authority, and of course it's the job of this court to keep them in the box that they're supposed to be in. The real problem, I think, that arises with the legislature's act is a conscientious effort to avoid the constraints that are put on them. And these constraints come from a variety of constitutional provisions, and one that is not mentioned as much in the briefs, but I think is worth pointing out. It's a constraint the legislature has put on itself. But the obligation of biennial budgeting, the rainy day fund, the definitions of general state revenue, the nature of a dedicated fund, and then a constraint that the legislature is self-imposed and they can lift and chose not to, which is a balanced budgeting. So they want to have a balanced budget, and so they want to tell people they have a balanced budget, but of course that is a self-imposed constraint that they want to avoid when they can. And what they did here, unique in the history of the state, they've never done this before, they created something that they label as a dedicated fund, but the fund springs into existence, sucks out $1 billion, spends the $1 billion, and disappears immediately. And I would say that's hardly a dedicated fund. That's a conscious attempt to avoid what is a dedicated fund. And I freely admit the Constitution doesn't have a definition of a dedicated fund. But what the legislature consciously and intentionally did, and said they did, was try to ensure that they had revenue that did not fall into the definition of general state revenue in only one single bill in one single instance for 1 year. So every other dedicated fund that the legislature has ever created, and there's one constitutional one, and there's a variety of other ones, of course Mr. Eyman has done a great job of pointing all those out. Every other dedicated fund that the legislature has ever created is something that is created as, you can't say perpetual because they can always revoke them, but they have to revoke them with another vote. They've never before created a dedicated fund that they create, deposit money in, take money out of, and disappears in the course of a single vote. And so I think it's notable that what they've tried to do in this biennial budget is avoid putting money in the rainy day fund by simply labeling money that otherwise would undoubtedly fall within the definition of general state revenue as a dedicated fund, but then not actually have it really be dedicated in the sense that it disappears almost immediately. And so while Mr. Eyman is correct about the legislature's plenary authority to legislate and make these decisions, I think what we see in this case is an attempt by the legislature to avoid the group of constraints that the people have put on them. And so in 10 years of the rainy day fund, of course the rainy day fund is a constraint on the legislature. revenue comes in, they can't spend it if they're constitutionally obligated to put it in a rainy day fund. They have never before attempted to avoid that constitutional constraint by this conceit of relabeling a revenue stream. So when the revenue stream was created in the first instance, that revenue is levied and put into general state revenue. And according to the initial statute, those tax streams are part of general state revenue. Then they decide, well, we need to have more money go to the McCleary fix. And rather than call for the constitutionally required supermajority vote to get the money they wanted for that, they said what we can do instead is avoid a fight. Those are the very words of the sponsor of the legislation. Avoid a fight, avoid a supermajority vote where we don't think we have the votes for it, and create and dissipate a so-called dedicated fund in a single vote. And that dodge is absolutely an attempt by the legislature to avoid the obligation that the people put on them in creating the constitutional amendment, constitutional constraint on their authority of the rainy day fund. And so it's our view that they are intentionally avoiding a GSR. That is, they're taking a stream of money that was originally defined as GSR and attempting to redefine it out of GSR in a single moment and then eliminating that definition again. And I would suggest to Your Honor that if you look at the web of constraints that the people have put on the legislature in their taxing power, in their spending power, in their obligation to save in the rainy day fund, what you find is that this particular attempt to swap money in and out that rapidly is in fact avoids their constitutional obligation. And so while it is an attempt to neatly avoid GSR definition, I would suggest that it's not appropriate to call this a dedicated fund, and it is in fact instead merely an attempt to avoid the constitutional obligation of the 60% supermajority to keep those monies out of the rainy day fund.
So, but Mr. Ard, would you agree or not that the Constitution does in fact anticipate that the legislature can change the calculation of the general state revenues by amending the statutory treatment of the revenues? Can't they do that?
Yes, Your Honor. In this case, though, what they did, they certainly did change the definition of the treatment of these revenues. But I would suggest it's not appropriate to, you need to look behind the label that they did and decide, does the treatment that they engaged in comply with their variety of constraints on them? And where that so-called dedicated fund, that's what the legislature says it is, isn't really a dedicated fund at all. It's not a fund. It's an accounting trick. It's not as though they created a fund and said, for 10 years we're going to have a property tax, and half of the property tax is going to go into a dedicated fund and half will go into general state revenue, and then in later years maybe they decide to change those. They did in a single act the creation, funding, dissolution, and dissipation of a so-called dedicated fund. I would suggest that's not dedicated, in part because it's not lasting, and in part because the legislature very expressly said that the reason for making this label was to avoid the constitutional obligation of a 60% supermajority vote on how they allocated those funds.
But you already, and I just want to make sure I understand, you concede that there is no definition of dedicated fund. I mean, you're trying to get behind what's going on here, but
there is no definition in the Constitution of dedicated fund. That's absolutely true. But I think one way to identify what is and is not a dedicated fund is in fact to look at constitutional practice in this state. And the legislature has long-time constitutional practice of what is and is not a dedicated fund. And setting aside the unique constitutionally established one. Other dedicated funds last. They last for a long time. And they have never before claimed that a one-time reallocation of money is a dedicated fund under the state constitutional definition. And so I think it is appropriate in trying to determine what is and is not a dedicated fund to actually look at the legislature's past practice. And you will see that this is an absolutely unique occurrence since the establishment of the rainy day fund. It's the only time they've ever tried to avoid their rainy day fund obligations and avoid the supermajority vote requirement of that portion of the Constitution by creating an effervescent fund.
And that was really the point of the declarations that were submitted by
Yes, Your Honor.
Mr. Taylor and Mr. Zarelli.
Yes, Your Honor.
Thank you. I interrupted you with asking you questions. Did you have any other
No, it was a good
argument?
time for the interruption, Your Honor. Thank you.
Thank you, Mr. Arndt. Mr. Even, I'll give you some additional time. I noticed you had not used your full time, and it would normally be the court's practice to give the moving party some additional rebuttal time. So does 4 minutes sound acceptable?
It does, Your Honor. In fact, I have 2 points that I'd like to make very quickly. The first is, we've heard here, I think for the first time, an argument about what Mr. Ard characterized the Education Legacy Trust account as being an effervescent fund, that it springs into existence and then goes away. That's nowhere in the briefing, and for good reason. It is absolutely wrong. The Education Legacy Trust account is a permanent fund in the state treasury. In fact, I could complain here of being, getting hit with an argument for the first time, an oral argument that's nowhere in the briefing, except that I happen to know a little bit about the Education Legacy Trust account because I've litigated it before. It is a permanent account that has other revenue sources besides the $935 million for fiscal year 2019 that's at issue in this case. For example, it is where estate tax revenue is deposited. There may be other money that flows into it as well, but that the idea that this is simply a fund that pops into existence to receive this money at one time and then goes away is simply unsupported and untrue. It is a very significant fund in the state that has, I was going to look here at a note, I think I may actually have, no, I'm sorry, I don't have my note, but as I recall, it has a current balance of somewhere or not a current balance, an end of this biennium projected balance of somewhere in the hundreds of millions of dollars. It is a significant account, not a here today, gone tomorrow gimmick or vehicle. Now, the other point is Mr. Ard makes reference several times to what he calls a web of restrictions on the legislature, yet he never points to any constitutional language constituting any component of that web. What's very notable here is that the state constitution defines general state revenue not by restricting what revenue must go into the state general fund, but simply by making reference to it and providing for consequences of legislative choices. So GSR is defined as all state money received in the treasury from each and every source, with exclusions including the one for money received for taxes levied for specific purposes and required to be deposited for those purposes into specified funds or accounts other than the general fund. It never says anything to restrict the legislature's choice about what money it is that's going to be levied for a specific purpose as opposed to a general one, or be deposited in the general fund or somewhere else. With that simply leaves us with nothing left to Mr. Eyman's case. The definition of general state revenue is quite clear that this revenue is not general state revenue. And I'd ask the court to dismiss the case.
Thank you. Well, I'll say a few things. First of all, both parties agree that summary judgment is the proper way for this case to be resolved. What that means for people that are in the courtroom is that there is an agreement by the parties that the facts are what they are. It's a legal question to determine whether what we've heard discussed about how the legislature approached this issue, whether they did so in a lawful, legal manner. And while the state had filed their request for the court to grant summary judgment, Mr. Eyman, citing other law, stated, we agree with that standard, but we think the law supports ruling in our behalf. And so what both parties are asking the court to do is to look at the relevant law that I will state that both parties, in my view, did an excellent job of putting forth their legal arguments based upon the facts with their supporting declaration, citing to the appropriate case law. And it really was a matter for the court to take time to carefully go through the cases cited, to go through the constitutional provisions, to basically take apart what both sides had submitted. The purpose of oral argument is really to give both parties that opportunity to further explain what they put forth in their briefing, and for me to be able to ask questions if I feel the need to. After reviewing and hearing from the parties, I am going to grant summary judgment on behalf of the state and dismiss this action.